I'd like to talk with you a little bit about some of the common defenses to sex crimes accusations and how we may be able to approach each one and utilize them to the best of our clients' abilities and try to make the most out of any of those available defenses. The problem with many sex crimes cases is that many of them are he said, she said, or he said cases, meaning two different people have two very different stories or memories of a particular incident. And the difficulty is that it then comes down to a discretionary call by law enforcement or by prosecutors on who they believe. Sometimes that is just simply out of our control. And so, what I tell a lot of my clients and prospective clients is that you're not hiring us to necessarily prove that you didn't commit a crime. Oftentimes, our job is to just make it difficult for the state or government to prove that you did commit a crime. And again, that puts some people in a position where they feel very uncomfortable because they want to make sure and assert their innocence. But unfortunately, that's not always available. That's not always a possibility. And so, again, trying to muddy the water or trying to make it as difficult as possible for the government to obtain a conviction or for law enforcement to finalize an investigation that appears very lopsided or identifies one of our clients as the perpetrator of a crime often is the best course of action. Sometimes and often the primary issue in a case is consent. And when it comes down to consent, again, it's going to be a he said, she said case on many occasions. One person claims that they didn't consent to a particular act. Another claims that it was completely consensual. And so what we have to look at is all of the circumstantial factors that may weigh in our favor to try and convince law enforcement or a prosecutor that this was in fact a consensual act, or at a bare minimum, to maybe question whether or not they've got sufficient evidence to convince a judge or jury beyond a reasonable doubt the act or situation was in fact non-consensual. The way that we do that, again, is by trying to collect and document and gather and then effectively communicate as much of that muddy information or various pieces of information that will call into question whether or not the act was in fact non-consensual. So we're trying to gather all of these circumstantial facts, and the circumstantial facts can include a variety of things. Utilizing a private investigator to interview witnesses who may or may not have knowledge of something that happened or is claimed to have happened is hugely important. Oftentimes, if there's an allegation of an act having happened at a party or between two individuals, the one person claims it was non-consensual. Interviewing as many people as possible who had observation or firsthand contact with either the suspect or the alleged victim is very important because all of those circumstantial points of view can be very relevant and can be the difference between a judge or jury believing that our client committed a crime or not.